Mr. Jeffries on David Boyd.
Yes, Your Honor.
Morning.
Morning. Good morning.
Good morning, sir. Are you David Boyd?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Let me get it pulled up the right way real quick.
Judge, what we're doing is pleading him to the, it's the same offense, deadly conduct, just under 22.05A, which makes it a class A misdemeanor.
05. Mr. Boyd, in cause number 25 DCCR 0720, the state has elected to proceed on the lesser included offense of a class A misdemeanor of deadly conduct, and that's from March 20th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablets some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Jeffries? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Boyd is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings, and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have conviction on your record. And at the end of the probation period, if you successfully complete it, the case will actually be dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the county jail for up to 1 year. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's sitting at that desk right over there. She's going to call you up to her desk to go over all of your paperwork when she's ready. All right, good luck to you, sir. Thank y'all for working this out.
Thank you,
Thank
Judge.
It's
Thank you.
Yes, sir.
gonna be hard to get through a bunch of words.
Now
It's gonna be hard.
Now I get to go use the teacher.
Have fun. Harold Denton. Yeah, yes. Have you ever been on Plea? Good morning. Good morning.
Sure, how many count you're wanting to plead to on this one, Judge? There's an agreement for 7 years TDC.
Okay, I'll take a look at the,
Waiving the evidence you don't deem necessary.
are you Harold Denton?
Yes, ma'am. How are you?
Good, thank you. And, Mr. Lewis, will your client waive the formal reading of the motion?
You do it, Judge.
Mr. Denton, in cause number 21-37744, I have a motion to revoke the community supervision. Shows that you were placed on probation October 20th of 2021 for the offense of assault on a peace officer, a 2nd-degree felony, and that was a 10-year prison sentence that was probated for 10 years. Is that correct? This motion alleges that you violated your probation. It alleges in count 1 that you failed to report to the probation office as ordered September 26th, October 17th, November 13th, and December 1st of 2025. And is that true or not true?
True, Your Honor.
Count 2 alleges that you failed to immediately report your home address and phone number also to the probation office as required. Is that true or not true?
It's true, Your Honor.
Count 4 alleges, I'm going to dismiss 3. Count 4 alleges that you failed to be placed on the mental health initiative caseload as ordered due to the fact that you absconded and you were unavailable for placement. Is that true or not true?
Yes, ma'am. That's true. I had
Count.
difficulties.
I'm sorry.
I had some difficulties. They stole my medications from my backpack at the bus stop, and I just
Okay. Count 5 alleges that you failed to successfully complete the BIP program. Is that true or not true?
The what program?
BIP, the battering intervention and
This is true, yes.
okay. I think with the agreement, if y'all are okay, that's fine.
9 was the failure to complete.
There we go. 9, count 9 alleges that you failed to enter and successfully complete the safe P outpatient aftercare. Is that true or not true?
Aftercare is from I successfully completed this. The
Right.
in-house system.
This is just the aftercare. You got to do the whole thing.
Yes, ma'am.
All right. Did you enter your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily?
This is true. Right.
And did you plead true to those counts that you pled true to freely and voluntarily?
Yes.
Okay. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Denton is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Reassess your punishment in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
Yeah, he was on strike probation. He definitely beat that.
Well, his was in 21, and I think we started, I think it was 22 or 3 when I started reading it. So in my mind, if it was 22 or before, because I can't remember, I just do it again.
Yeah.
I can't remember the exact day. And I need to say so many more words today.
That's what I was looking at. Sounded like we only had you for a little bit more.
Yeah, luckily it's not a big day. Perry Hurd, morning, are you Perry Hurd Jr.? I'm sorry.
Right.
Okay, and this is cause number 26 DCCR 0052. Mr. Hurd is charged with harassment of a public servant. I want to take judicial notice of the court's file. I received a report from Dr. Capon with regard to competency, and that report is dated June 23rd of 2026. The finding in the report is that Mr. Hurd is competent to stand trial. Is there any other evidence with regard to competency?
No, Judge. Not from the state.
Right, that at this time, based on that report, I am going to find that Mr. Hurd is competent to stand trial. And what is the announcement?
Judge, I have received a new offer this morning since visiting with Mr. Hurd in regards to his offense, Judge, and I think it's something that could possibly resolve this issue. If I can just get a short reset in so I can explain that and go over with
Sure.
Mr. Hurd.
You want a week or 2?
About 2 weeks.
Okay, we'll reset the case 2 weeks, Mr. Hurd. Mr. Lewis will be out there to go out and visit with you about all your options, and we'll get an announcement at the next court date.
This is the court date for the day, right?
I'm sorry,
So this is my court date.
today's your court date, but I'm gonna move it for 2 weeks so that Mr. Lewis can spend some more time with you going over everything, okay?
All right, so I've been in there long enough to let's see if I need time served or how.
Talk to Mr. Lewis about all your options and he'll let you know what they are, okay?
Okay.
All right, he'll be out there to go over all of it and
So
make
this
sure,
is looking good for him.
I'll come
he'll be out there to go over all that, okay? You can go back with the bailiff.
I'm gonna talk to y'all whenever.
Denisha McMillan. Morning, ma'am. Are you Denisha McMillan?
Yes, ma'am.
And this is cause number 26 DCCR 0647. And I'm going to take judicial notice of the court's file in Ms. McMillan's case. Ms. McMillan was evaluated for competency to stand trial by Dr. Capon. I received that report dated June 23rd of 2026. The finding in the report is that Ms. McMillan is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Not from the state.
Then at this time, based on that report, I am going to find Ms. McMillan competent to stand trial. Mr. Lewis, will she waive the formal reading of the indictment?
She does.
Ms. McMillan, you're charged with the third-degree felony offense of injury to an elderly individual from March 16th, 2026. And how do you plead to that charge?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
No, ma'am, I'm just ready to do my time.
Well, it doesn't work like that. If you didn't do this, then you get a trial. So here's the thing, before you go any further, when you stood over in front of the clerk a minute ago, you raised your right hand and you said you promised to tell the truth, the whole truth, right?
Yes, ma'am.
So if you're guilty, you're guilty. If you're not guilty, then we'll get your case set for trial, but I'm not gonna allow you to plead guilty with something you didn't do.
Yes, ma'am.
Okay, so if you want to talk to Mr. Lewis for a minute again, that's fine. If you're gonna take responsibility, then I'll ask the same questions again, but that's gonna be up to you.
Yes, ma'am.
What do you want to do?
I mean, I don't have anything to say with it. I know I never touched him.
Okay, so then I'm going to delete this paperwork, and what we'll do, Ms. McMillan, is I'm going to set your case for trial.
Yes,
When I set your case for trial, Mr. Lewis is appointed to represent you at this point. He handles a lot of cases for me here as a appointed attorney. With your permission, I can release him and I can appoint another attorney who could get ready for trial a little quicker. Is that okay with you?
yes, ma'am.
All right, then, Mr. Lewis, you're released. Ms. McMillan, we will get you an attorney appointed today. They'll be out to see you very soon to begin preparation for trial.
Yes,
All right,
ma'am.
you go back with the bailiff.
Yes.
And Mr. Smith, if you'll make a notation, make sure, obviously, that's. I mean, we'll see what the other attorney does, but I don't intend to keep that deal. I'm sure you don't either.
No.
All right, Kadisha Scott. Morning, ma'am. Are you Kadisha Scott?
Yes, ma'am.
And this is 26 DCCR 0797. Ms. Scott is charged with the first-degree felony offense of aggravated robbery from July 3rd of 2025. And what is the announcement?
Judge, in this situation, we have the complaining witness who's evidently been trying to get in touch with the state
Okay.
in regards with this issue. And actually, I talked to the complainant myself a few times where they've called me saying they've called trying to get in touch with the office. I've given them their number up there so he can get that taken care of. That's the main weight that we
Okay,
have on our end.
sure.
And Judge, I mean, in the meantime of that, of course, I would like to possibly either, I know we may not be able to take care of it this morning, but at least get a bond hearing set from Ms. Scott until we can get that worked out.
Let's do this. I mean, is there any reason you can't try to get that worked out this week to get in touch with them?
This is a case I inherited from Mr. Coleman.
Okay,
The number that Mr. Lewis has for him is the number that we have in the file. We did send him a letter. Tommy sent a different letter than we normally send, and it was returned. So I don't know about the address, but the phone number apparently is good. I didn't have a message that he had called, but I will reach out to him.
okay. Let's do this. I'm gonna reset it 2 weeks, and that'll give Mr. Smith time to kind of get caught up, make that phone call, get in touch with them. If by that time, between now and then, if you want to go ahead and file a motion for bond reduction, that way everybody's on notice and we can have that hearing on that date if something else doesn't get taken care of.
Good.
Okay, all right, see you back in 2 weeks. Joshua Smith,
Judge, can you speak to somebody from?
yeah, the hold him for us. Morning, sir, you Joshua Smith. And so, Mr. Smith, before you came out, Mr. Lewis explained that some of the hesitation you have, that there's an agreement that you guys have worked out that you're willing to accept, but you're a little concerned because Harris County does things differently, I think, than we do. I just want to let you know how we do things. And then if you want to enter that plea, you can. If you want to go to trial, you can do that, okay? What I do is if someone pleads to an agreed plea, I do take that plea today, and then I reset your case for sentencing. During that time period, I have the probation do a pre-sentence report just so that I have more information when we come back. If for any reason at that time, there's something in that pre-sentence report that makes me say, you know what, I'm not going to follow this agreement. And what I do is allow you to withdraw your plea of guilty, and then we start all over. You go to trial or y'all work something else out. I'm never just going to give you something if I don't agree with what that is. That's not how we do things. So if that helps with that understanding, I'm gonna let you visit with Mr. Lewis again, and go over that, but it's definitely I don't do that. I never have, and I never would do that. I don't think that's actually the right way to do it. So you're pleading guilty based on an agreement. And so if you don't take that agreement, or if I don't take that agreement, we'll start all over. Okay, all right, y'all go back and visit.
Oh.
Again, you're Joshua Smith.
Yes.
And Mr. Lewis, will your client waive more reading of the indictment?
You do.
Mr. Smith, in cause number 25, DCCR 1439, you're charged with the first degree felony offense of fraudulent use or possession of identifying information in the amount of 50 or more from August 20th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1,
No objection.
it's admitted. Is there any evidence that Mr. Smith is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get that PSI done, and then we'll come back later for sentencing. Mr. Smith, what is your position with regard to bond based on that?
We're not opposed to a PSI bond on this, Judge. I believe there's a little bit of criminal history, but I think it'll be fine on this case.
So, Mr. Smith, what I'm going to do in your case is, based on the nature of your plea, is reduce your bond to $1,000. If you're able to make that bond, there's a couple of very important things about it, though. The first thing you do when you're released from custody, if you make that bond, is go to the probation department so you can get that pre-sentence report and started. You're going to get some information today, some paperwork, so that you'll know where to go. Also, if you bond, don't do that. If you don't show up, don't get that report done, you run the risk of me not accepting the plea agreement. If you're arrested for anything between now and when you come back, you obviously run the risk of me not accepting the plea agreement. And there's no, I was going to ask this a minute ago, there was no restitution or anything like that. All right, so you'll get some paperwork from probation this morning. If you make the bond, do everything you're supposed to. If for some reason you don't, they'll come out to the jail and do that pre-sentence report out there. Okay, see y'all back at sentencing.
Thank you.
No.